It's Guy DiMartino, a Northwest Indiana estate planning lawyer. You meet with more people and you get more and more questions regarding estate planning, probate, things that happens after folks die. I recently received a question and the person wanted to know, well, how do I get to see the will of somebody who dies? So there are pretty much two ways to get to see the will or understand what is in the will. The first is if you are an heir or a beneficiary or you are named under the will, the personal representative or the lawyer or whoever else is named in the will can read you or have you take a look at the will to see what the will says about what you may be getting under the terms of the deceased person's last will and testament. So that's the first way. If you're not a beneficiary at this point in time, you are not going to be able to find out what is in this person's will unless you were recently written out of the will, but that's for another day and another discussion. So the first way is that either the lawyer who might have the will, or there might be technically a reading of the will, or somebody will send you a copy of the will which explains what you might be getting under the terms of the will. Second way is this: if a probate is going to be opened, the will must be filed and accepted by the clerk of the court and the probate court. So the will have to be filed in the public record, and then in the state of Indiana recently, everything is electronic, so you should be able to look up the case in the county in which the will was docketed, and you should be able to click on it. And if you can't click on it, you might be able to send the clerk an email saying, hey, I would like to go ahead and take a look at this will, and they should be able to email it to you. Or you may have to go to the clerk of the court, give them the case number or give them the name and say, hey, I would like to have a copy of the will. And then you could go ahead and read the will to see the terms of the will. Because once a probate is open, the will becomes a public record. And that's one of the reasons why some folks will do trust-based estate planning, because the trust document does not go into the court or into the public record. And some people are concerned, especially if they have young kids, about the property that the heirs might be getting, and that people will go ahead and troll the public records and try to take advantage of folks' loved ones. So there you have it. If there is no probate open, you're going to have to speak to either the lawyer or the personal representative if you're an heir or beneficiary to find out the terms of the will. If a probate is going to be opened, you can wait until it's opened, and then the will become part of the public record. If you have any questions about an Indiana estate planning matter or estate planning litigation, you can always give me a call or shoot me an email. I am Guy DiMartino. Until the next time, have yourself a great day.